All right, thank you all for coming. The House Committee on the Judiciary will come to order, and without objection, the chair is authorized to declare recesses of the committee at any time. Coming to order. We welcome everyone to this morning's Member Day hearing, and I'll now recognize myself for an opening statement. Today, we have the opportunity to hear the views of our colleagues on both sides of the aisle about their legislative interests and priorities on matters within this committee's jurisdiction. The Judiciary Committee is responsible for a broad array of issues, including the federal judiciary, criminal justice, administrative procedure, bankruptcy, civil rights and civil liberties, constitutional amendments, immigration, intellectual property, oversight, antitrust, and much more. Already on a bipartisan basis, we have passed several bills to lower prescription drug prices, a number of bankruptcy bills providing much-needed financial relief for veterans, family farmers, and small businesses, and legislation to permanently reauthorize the 9/11 Victims' Compensation Fund. We've also examined the state of competition in healthcare markets, performed oversight on the Copyright Office and the Patent and Trademark Office, and held a series of hearings as part of the committee's bipartisan investigation of competition in digital markets. This is just a small sampling of what the committee has accomplished this year, and we'll continue to have an active and varied agenda over the rest of this Congress. I look forward to hearing from my colleagues on matters of interest to them to help inform this work. The House of Representatives is fortunate to have a broad and diverse array of views among its members, and I know that this committee's work will be strengthened by hearing from our colleagues. Okay, I now recognize the gentleman from Texas, Mr. Gomer, for his opening statement.
I thank the chair and appreciate all our member friends being here today. This is a big deal, and it's important for us to, I think, we don't do this in my other committee, but to be able to come together and talk together like this, hear from people that are outside the committee, and that doesn't happen enough, and so I'm grateful we're doing this. And since we are, I have a case that was just decided, which makes some legislation. I filed a companion to the Senate bill that would outlaw female genital mutilation, be called the Federal Prohibition of Female Genital Mutilation Act of 2019. We'd been told, well, we're not going to take that up because that's in the courts and it looks like it'll take care of itself. Well, it did. And yesterday we got the report that the Sixth Circuit had struck down Congress's effort to intervene and have female genital mutilation considered illegal. That effort's been struck down, and so it makes this H.R. 3583. Like I say, it's got a Senate companion, and it's exactly the same, so we could get this into law and start protecting young girls and women very quickly. And the ranking member, Mr. Collins from Georgia, is co-signed on, as the former chair, Mr. Sensenbrenner, is, and numerous others. So I would encourage the majority, let's go ahead and bring this bill. Let's do it. I found out just before we started the committee that actually there is a new bill being prepared that's almost identical. It references the Sixth Circuit, but so the majority can file it. And of course, the line here in Washington is, it's amazing what you can get done if you don't care who gets the credit. But I think it'd be better to use 3583 because it has a Senate companion. We could get this into law. We could be protecting young girls and women from the horrible brutality that so many have had to experience. And one other thing I would like to bring up is I know OGR had hearing on DC statehood. The founders carved out this area, the District of Columbia, from Maryland and Virginia, 10 square miles, because they did not want any jurisdiction be able to hold them up and have that kind of power. And statehood would change the entire thinking of the founders of having this enclave that was a federal enclave. And it bothered me when I first got to Washington. I saw the license plates, taxation without representation. And then I got to thinking about it. Well, wait a minute, that is something very important to us. And Ben Franklin said, if we don't elect one member of parliament, then they have no right to ever put any tax on us. And then I found out Puerto Rico, they don't have a federal income tax. Mariana Islands, Guam, all of these territories that don't have a full voting member, they don't pay federal income tax. The District of Columbia does not have a full voting member. They pay federal income tax. That really isn't right. So in all but one of the sessions since this first came to my attention, I filed a bill, and it should be finished today, to refile it again in this session, and that is no federal income tax for the residents of District of Columbia. They do not elect a full voting member of Congress. They should not, just like Puerto Rico, all our other territories, they shouldn't have to pay federal income tax. If the majority prevails at some point and they have a full voting representative, then yes, it would be okay to have a federal income tax. But I still think it is grossly unfair that we treat them in a way we don't treat any other territory, any other non-state. And so I hope we'll do that for the people of Washington, D.C. It's really an injustice, and it does bring to mind some of the slogans that fired up people in the Revolution. So those are two things that I would hope the majority will take up: protecting girls and women and treating the residents of the District of Columbia like we treat everybody else that doesn't elect a full voting member. And I thank the chair for indulgence. Thank you very much, and thank y'all again.
Thank you very much. Before we proceed with the members, I just want to note that there is a judiciary bill on the floor right now, so many of the members of the committee are there involved in the debate on that bill. Without objection, all opening statements will be included in the record, and we're proceeding today on a first-come, first-served basis. Please note that each of your written statements will be entered into the record in its entirety, and I'd ask that you summarize your testimony in 5 minutes. We'll now hear from the gentlelady from California, Ms. Chu.
Chair Scanlon and members of the Judiciary Committee, thank you for holding this Member Day hearing today. As a former member of this committee, I appreciate the opportunity to speak about some of my priorities, especially around immigration policy over which you have jurisdiction. I'm grateful for the work that this committee has already done in marking up and passing the Dream and Promise Act of 2019 and holding numerous hearings on the critical issues of family separation and detention. This administration has created an unprecedented attack on immigrant communities and, through its policies, divided families. I'm deeply disappointed that the Supreme Court upheld the third iteration of the ban that excludes people from predominantly Muslim-majority countries. That is why I introduced H.R. 2214, the No Ban Act, which repeals all iterations of the Muslim ban, the asylum ban, and extreme vetting for the refugee executive order. It also requires the administration to consult with the State Department and the Department of Homeland Security and to brief Congress before making such suspensions. My bill has 172 co-sponsors, and I'm pleased that the committee is planning to hold a hearing next week to examine the injustice of the Muslim ban policy. I hope the No Ban Act can be marked up and brought to the House floor for a vote soon. But this administration is going even further. It is attacking families that already live here in the United States. I am the author of the H.R. 3222, the No Federal Funds for Public Charge Act, which would block any funding from being used to implement the discriminatory public charge rule put forth by the Department of Homeland Security. Immigrants who use public benefits like food stamps or Medicaid, benefits that they have paid into through taxes, should not be penalized when they apply for green cards or other adjustments of immigration status. Already, we are seeing a decrease in healthcare enrollment in communities fearful of using services that they are actually eligible for. This policy only leads to more sickness and hunger in our communities. I also believe that we must do better by the immigrant children who are crossing the border and being detained in emergency influx shelters. I personally visited Tornillo last year and was horrified at the conditions at that camp. My bill, H.R. 1069, the Shut Down Child Prison Camps Act, was introduced with Senator Jeff Merkley of Oregon to make sure that any facilities where children are held that they comply with the protections in the Flores Settlement Agreement. Luckily, Tornillo has been shut down, but the facilities like those in Homestead, Florida, continue to be operated. I also urge this committee to address the family-based immigration backlog. There are currently over 4 million people in the family immigration backlog waiting to reunite with their loved ones. The average wait time for a permanent resident to sponsor an unmarried son or daughter from Mexico is over 20 years. My bill, H.R. 3799, the Reuniting Families Act, modernizes our family immigration system and provides relief to families who've been separated for years. Specifically, the bill recaptures unused visas lost over the past 2 decades, increases per-country limits, and prevents children from aging out and losing their place in line due to bureaucratic delays. The bill also reforms our immigration-based immigration system by clearing the backlogs and increasing the number of visas from 55,000 to 80,000 visas per year. Finally, I'm planning to reintroduce the Protect Our Workers from Exploitation and Retaliation Act in the coming weeks. The POWER Act protects U-visa eligibility for immigrant workers who report unsafe or unfair labor practices. It also strengthens labor agencies' investigative powers and allows a stay of removal and work authorization for workers who file a workplace claim. Thank you again for allowing me to testify, and I look forward to working with the committee on passing legislation to address these issues.
Thank you very much. Next, we'll hear from the gentlelady from Virginia, Ms. Loria.
Thank you, Madam Chair, and members of the Judiciary Committee for giving me this opportunity today. As the mother of a 10-year-old daughter, I can tell you there's nothing worse than watching your child in pain. We all want what is best for our children, and I trust that the members of this committee share my concern for children suffering from rare or debilitating diseases. The unfortunate reality is that our outdated marijuana laws cause chronically ill children to suffer from unbearable bouts of pain every day. Your committee can spare these children from this unthinkable agony. That is why I'm here today to encourage the Judiciary Committee to act quickly to advance legislation to remove marijuana from the controlled substances list. It defies logic, science, and compassion that marijuana is classified as a Schedule I drug alongside heroin. As a mother, I will not stand on the sidelines while our outdated marijuana laws cause an undue hardship on our children and our families. That is why I'm here today to make sure that my colleagues hear the impact of inaction in reforming our marijuana laws. Madison is a 10-year-old girl from Hampton, Virginia. When she was just 5 years old, Madison was diagnosed with a rare form of brain cancer. Only 200 adults and children are diagnosed with this form of cancer every year, and the 10-year survival rate is only 20%. Over the last 4 years, Madison has had multiple major surgeries, severe bouts of pain, and very difficult treatments. After numerous treatments, Madison's family began to experiment with cannabis products to make life more bearable for her. And thankfully, it worked. Madison is now able to go to school, play with friends, and do things that most 10-year-old girls do. I would love to say that this is the end and everyone lived happily ever after, but that is not the case. Our archaic medical marijuana policies prevent Madison from receiving her treatment on a legal basis. Since cannabis is a Schedule I drug, Madison's mother could be arrested, have her property seized, or lose her daughter to Child Protective Services by doing what is best for her daughter. Madison's mother is risking everything, but she's doing exactly what any mother would do for their child. Today I ask you, aren't we better than this? Why can't Congress stand up for children like Madison? Our marijuana laws are not only out of step with the scientific community, they're out of step with the American people we were sent here to represent. According to a recent poll, 93% of Americans support medical marijuana. Children like Madison with rare diseases do not have time on their side. I urge the committee to act quickly to advance legislation that deschedules marijuana so that we can stand up for children like Madison in our communities. I thank you for the opportunity to speak before you today.
Thank you very much. We'll now hear from the gentleman from Wisconsin, Mr. Gallagher.
Thank you. I'd like to talk today about my bill, H.R. 1522, the Congressional and Executive Foreign Lobbying Ban Act. This bill would prohibit members of Congress, high-ranking executive branch officials, and flag and general officers of the armed forces from lobbying for foreign principals under the Foreign Agents Registration Act, or FARA, upon their retirement from government service. Public trust, and we've all heard these statistics, in government has reached near all-time lows. Only 17% of Americans say they trust their government. In Washington, all or most of the time. That figure, just for historical context, was 73% when President Eisenhower was in office 60 years ago. Today, stories of foreign influence and lobbying increasingly dominate the headlines. Americans who are already skeptical of their government see highly trusted former government officials, representatives, and even members of the military selling their influence and reputations to represent foreign entities, including some whose interests directly contravene those of the United States. For example, numerous former representatives, senators, and executive branch officials have signed up to work on behalf of various state-directed Chinese interests, including Huawei and ZTE, Chinese telecom companies that are in a life-or-death struggle with Western-aligned companies for the future of global communications. This is not an accident. The Chinese Communist Party's goal to use the swamp to advance its interests and undermine our national security is hiding in plain sight. We cannot let them succeed. To better defend ourselves, we need to update our laws regarding foreign influence. When trusted officials turn around and offer their reputation and experience in service of our adversaries, they damage public trust in our government while advancing hostile interests. Therefore, my Congressional and Executive Foreign Lobbying Ban Act is a targeted reform that aims to prevent some of the worst abuses of access we've seen in recent years. This is not about restricting freedom of speech. Rather, it's about preventing those with the most extensive insider connections from profiting off those connections to the detriment of our national interest. Again, this ban extends only to former members of Congress, high-ranking executive branch officials, and flag and general officers. And I believe this legislation is a concrete step that should bring both sides of the aisle together. Passing this bill would show the American people that we are serious about doing away with some of the most egregious peddling of influence that we've seen in the swamp, and certainly the kind that most directly undermines our national security. So once again, I thank you for giving me this opportunity to speak here today. I hope we can get ahead of this issue, which I worry is going to get worse in the future as this competition with China proceeds, and I urge this committee to swiftly take up and pass H.R. 1522. Thank you.
Thank you, Mr. Gallagher. I was remiss before. Do any members of the committee have questions for our witness? Hearing none. Thank you. All right. Next, we will hear from the gentleman from Montana, Mr. Gianforte.
Thank you, Madam Chair, for holding this hearing and for Members' Day today. I know this committee's been busy, this Congress, with impeachment. The committee held its first hearing this week, and by all observers, it was a circus. There were clowns, walkers, fire breathers, and shell games. The only thing missing was the big top. In addition to this first impeachment hearing, the committee also held numerous hearings on the work of Special Counsel Robert Mueller. The committee voted to hold the Attorney General in contempt for following the law. And Democrats have spent the last 3 years grasping at straws to reverse the results of the 2016 presidential election. And that's a shame. There are serious issues confronting our country that this committee should be focused on. And yet this committee is hot under their collar with impeachment fever, driving the committee to neglect those serious issues. One of these serious issues is addressing our broken immigration system. The American people said immigration is the most important problem facing our country, according to a Gallup poll. There's a crisis on our border. In May, Americans saw the highest number of border apprehensions in 1 month in 13 years. Cartels are profiting from drugs and human trafficking. I visited the southern border in Arizona and saw the crisis firsthand. Ranchers I talked to described finding dead bodies on their properties. When I talked with Border Patrol agents, they told me they need more equipment, better body armor, and physical barriers that actually work. What it all comes down to is that our immigration system is broken. This committee focused on fixing it last year, replacing visa lotteries with a merit-based system, ending chain migration, and yes, building a wall. But what's taken over this committee this year? Impeachment fever. Episodes of mass violence have shaken our country. Cowardly individuals attack and kill innocent Americans in acts of domestic violence. To address this crisis, Democrats propose infringing on our Second Amendment rights of law-abiding citizens. And don't just take my word for it. Democrats have claimed for years that nobody's coming for anybody's guns. But a progressive Democrat running for president just last week destroyed that myth, admitting on national TV that they are coming for our guns. Just look at H.R. 8. Democrats created an anti-Second Amendment bill. No subcommittee hearing was held. No subcommittee markup was held. This committee held no hearings. It was considered and marked up in 1 day. So how would H.R. 8 prevent tragedies of mass violence? It wouldn't. In fact, it would make it illegal for a victim of domestic abuse to borrow a gun for protection. And it is a dangerous step towards a national gun registry and ultimately confiscation. Most recently, this committee marked up a series of bills that provide no solutions, just false hope. It runs the gamut, from imposing arbitrary limits on magazines to depriving law-abiding Americans of their Second Amendment rights without due process. These efforts undermine the rights of lawful gun owners. Do you know who won't be impacted by these false hope laws? Criminals. So maybe this committee could reaffirm the importance of enforcing existing laws to keep guns out of the hands of criminals, like forbidding straw purchases or prosecuting convicted criminals who try to buy guns. Maybe it could focus on keeping guns out of the hands of criminals. Maybe it could focus on evidence-based solutions that don't infringe our Second Amendment rights. But instead, this committee has been taken over with impeachment fever. And Madam Chair, if you have to investigate something, if your fever just won't break, maybe you could bring Inspector General Horowitz from the Justice Department to discuss the actions of the FBI, CIA, and Special Counsel. Maybe you could do more than take a shallow look at the deep state. Thank you for this opportunity to share my views with the committee.
Thank you to the gentleman from Montana. I'm sorry, yes, Montana. We'll now hear from the gentleman from California, Mr. Takano.
Chairwoman Scanlon, Mr. Klein, or is it Mr. Collins, and members of the committee, thank you for the opportunity to testify today. I'm a little confused by the change in nameplates. I'm here to discuss the deportation of non-citizen military veterans. Every day, these brave servicemen and women risk their lives in service to our country. Their sacrifice should be honored. In June, the Government Accountability Office, the GAO, released a report at the request of my office and Congressman Juan Vargas to determine the scope of service member and veteran deportations. I was deeply alarmed by the findings in the report, which shed light on a systemic failure within the Department of Homeland Security to identify and track information on potentially removable veterans. I was equally troubled to discover that while Immigration Customs Enforcement, ICE, has certain policies in place to track these veterans, ICE routinely failed to adhere to those policies. This breakdown has directly resulted in the deportation of veterans whom have proudly served our nation. I must depart from my script. Many Americans do not believe that our nation is deporting men and women who have worn the cloth of our nation. But it is true. It has been done, and there are many veterans that are living outside of our country who have been deported. These veterans have dutifully served us, and as a country, we need to fix this grave injustice. Congress has an important role to play in making sure all veterans have access to the benefits they rightfully earned and providing a clear path forward to citizenship for those who dream of becoming citizens. Regardless of where they were born, these veterans have taken an oath to fight and protect this country, and they have proven themselves time after time. We must not waste another day. Our veterans need help, and they need it now. Steps must be taken to ensure our veterans do not continue to fall through the cracks of a broken immigration system. I, along with some of my House colleagues, will be presenting a comprehensive package to address the significant and unique challenges our non-citizen veterans face. A comprehensive package would include several provisions to strike at the heart of some of the fundamental root causes of these deportations. It will be important for this chamber and this committee to consider an approach that will take an inventory of all veterans who have been deported from the United States, establish clear protocols to identify and track potential veterans who may be subjected to immigration proceedings and face the specter of deportation, and establish a process to ensure that veterans moving through the judicial system stand a fair chance of being recognized for their service. A common misconception about veterans is that they reliably self-identify and announce their veteran status while facing deportation proceedings, though we know that this is simply not true. Under a fair and just system, the totality of a non-citizen veteran's service history would be presented before a judge during any deportation proceedings. However, this is rarely true today. It is my view that no veteran should be deported without a considerable review of their case and their service to our country. Those who have already been forcibly removed should be given a fair chance to return to the country they love as naturalized citizens. Our government is failing our non-citizen veterans, and we must do better as a nation. I urge this committee to take seriously the issue of deported veterans and urge your utmost consideration once a comprehensive legislative package is brought before this committee. Thank you, and I yield back.
Thank you, Representative Takano. Next, we will hear from the gentleman from Washington, Mr. Newhouse.
Good morning. Thank you, Madam Chair Scanlon and Mr. Klein. Appreciate the opportunity to testify in front of the House Judiciary Committee this morning. I've come to speak on a crisis that affects communities across our nation, the crisis of missing and murdered Indigenous women. Native women throughout the country face a murder rate 10 times higher than the national average, with 84% experiencing some kind of violence in their lifetimes. In my home state of Washington, Native Americans make up about 2% of the population. But a recent survey by the Washington State Patrol shows that Indigenous women account for 7% of the state's reported missing women. Unlike other crimes, this problem affects communities in both highly populated urban areas as well as rural areas. My congressional district sits at the epicenter of this crisis in the state of Washington. There are currently 31 open MMIW cases on or near the Yakama Nation in central Washington, including 7 cases in just the last 5 years. This is in addition to 71 open cases in the greater Seattle metropolitan area. Not only is the sheer number of open cases alarming, but the lack of resources and tools law enforcement agencies have to combat this problem is staggering. The complicated jurisdiction between federal and tribal and local law enforcement has caused serious issues throughout many investigations, and the families and communities of these victims are left without answers. I could sit here and continue to spout the heartbreaking statistics or share gruesome details about the women who have gone missing or whose bodies have been found across the country, but the truth is, we don't even have the accurate data to truly understand the breadth of this problem. To truly understand their stories, it is best to hear directly from the communities that are affected. Our community in Central Washington has not been silent. Citizens of the Yakama Nation and other local tribes have hosted rallies and forums to raise awareness of this crisis and demand action. One of our local newspapers, the Yakama Herald Republic, has diligently highlighted the response and activism on the ground, providing resources for families and friends of missing Native women. I'm here today in part to draw attention to the request I have made to this committee to host a field hearing in Central Washington to discuss solutions to the MMIW crisis. My written request was delivered in June and has been echoed in letters from numerous tribes, advocacy groups, and women's organizations, yet we have yet to receive a response. This committee has held 26 hearings since those letters began arriving on your desks, but we have not been acknowledged. I would ask unanimous consent to submit for the record copies of the letters of my request, as well as letters from the Yakama Nation, the Colville Nation, the Puyallup Nation, the Samish Indian Nation, the Muckleshoot Tribe, the Nez Perce Tribe, the Washington State Women's Commission, the YWCA, as well as the missing and murdered Native Americans.
Those will be received without objection.
Thank you very much. A field hearing would provide members of the committee the opportunity to hear firsthand from the tribes, local law enforcement agencies, community members, and families who are dealing with this crisis every day. A visit to the Yakama Nation would help demonstrate the impact this crisis is having on our communities in Central Washington and around the country. I sincerely hope you will consider accepting my invitation. Thankfully, the current administration has been actively pursuing this local input. The Department of Interior is conducting a series of roundtable events with tribes and local law enforcement agencies across the country, most recently in Arizona and Alaska. While the DOI and the Bureau of Indian Affairs certainly have a role to play here, it is Congress must pay attention and do our part. I have worked with colleagues, including Norma Torres and Deb Holland, as well as others, on proposals that would provide immediate assistance. For instance, Savannah's Act and the Badges for Native Communities Act would develop guidelines and best practices to enhance the reporting and record-keeping of crimes against Indigenous women, improve communication between law enforcement and families of victims, and provide resources to tribal law enforcement to recruit, retain, and train officers to better investigate these crimes. There is strong bipartisan support for both of these bills, which have been referred to your committee. My colleagues and I stand ready to develop solutions that will work for local tribal communities and law enforcement. I hope members of the committee will join us in listening to the desperate pleas of these communities and seeking comprehensive solutions in bringing justice on behalf of women in these families. I thank you for your attention. Good morning.
Thank you very much. We'll now hear from the gentlelady from Missouri, Ms. Hartzler.
Thank you, Madam Chair, Representative Klein, and distinguished members of this committee. So thank you for giving me this opportunity to address you today. Today, I would like to discuss three of my top priorities: school safety, border security, and combating sex trafficking. These three issues impact every one of our communities. That is why I introduced three bills to offer solutions to these challenges. The first bill I want to highlight is H.R. 1501, the Police Officers Protecting Children Act. This bill would give school districts the flexibility to allow off-duty law enforcement officers and qualified retired officers to carry a concealed firearm on school grounds. This issue came to my attention when one of my constituents, a 30-year retired veteran police officer, found that federal law prohibited him from volunteering to protect his grandchildren while he visited their school. My bill does not require schools to make any changes, but simply removes a federal barrier and allows school districts to decide for themselves if they want to allow otherwise qualified law enforcement officers the ability to protect our children on school property. For too long, we have witnessed countless and gut-wrenching acts of violence in our schools, and we have mourned, grieved, and called for action. We can no longer afford to stand by and call for action without engaging and offering solutions. That is why I introduced this important piece of legislation. The next bill I would like to discuss is H.R. 3968, the Eradicate Crossing of Illegal Tunnels, or EXIT Act. Last year, I visited the southern border and spoke directly with Customs and Border Patrol agents in Nogales, Arizona. The lengthy and burdensome process of filling illegal tunnels that cross the border and facilitate the flow of illegal narcotics into our country was a top concern. An agent explained that once a tunnel was found, it could take months to get through the environmental reviews and bid contracting process necessary to allow a crew to begin filling in a cross-border tunnel. For example, a tunnel was found in the Rio Grande Valley in January of this year and was not filled until nearly 4 months later. We should not allow bureaucratic red tape to get in the way of dealing with matters of national security, such as filling illegal drug tunnels. My bill expedites the approval process that CBP agents must undergo to destroy tunnels at the border. It allows the Secretary of Homeland Security to waive federal, state, and local environmental permits and reviews, expedites the contracting process, and clarifies that CBP and ICE have the authority to search for and remediate unlawful cross-border tunnels while patrolling the border. This bill is a common-sense fix that will save time and resources while also helping to prevent illegal drugs from entering our country. Finally, I've reintroduced the Empowering Law Enforcement to Fight Sex Trafficking Demand Act, a bipartisan bill that passed this House by voice vote last Congress. My bill, H.R. 1110, supports law enforcement agencies in their efforts to expand and develop sex trafficking demand reduction programs by enabling new funding through the Edward Byrne Justice Assistant Grants Program, or BYRN-JAG program. Since 2007, the National Human Trafficking Hotline has reported 51,919 sex trafficking cases in the United States, underscoring the harsh reality that sex trafficking has roots in thousands of our neighborhoods and cities across our country. According to leading researchers and law enforcement agencies, a primary cause of the growing number of sex trafficking cases is consumer-level demand. Despite the increase in influence of consumer demand, law enforcement is not being equipped with the proper funding to create or expand demand reduction programs that would put these sex trafficking buyers behind bars. By expanding the BYRN-JAG program, we can provide our state and local law enforcement agencies more flexibility in balancing their resources to combat sex trafficking. We, as members of Congress, must shed light on this horrendous epidemic and provide our law enforcement agencies with the adequate resources to attack the sex trafficking industry at its source. I ask my colleagues to support all three of these crucial efforts And I thank you for allowing me this time, and I yield back.
Thank you very much. Next, the committee will hear from the gentleman from Iowa, Mr. King.
Thank you, Madam Chair and Ranking Member. I appreciate the opportunity to address a number of bills that I'd like to see move before this United States Congress, and I'll try to get through about 4 of them in these 5 minutes. The first one would be the Heartbeat Protection Act, which made a lot of progress in the last Congress, up to 172 co-sponsors, 174 co-sponsors, and it had all the votes in this committee to pass out of committee without amendment, and it had the votes on the floor. There was a decision, I think, made higher up not to allow that bill to move forward, which I deeply regret, but the progress that we made in this Congress, in the previous Congress, did seem to launch or trigger an epidemic of heartbeat bills across the country. And at the heart of these heartbeat bills is the idea that once a heartbeat can be detected, the baby is protected. And so that swept through this Congress almost to the point of sending a bill over to the Senate. But also the states, there are at least 10 states that have passed some version of that, a couple of them before then, a number of them since then, including Iowa. And now we have 25 of the 50 states that have either passed a heartbeat legislation or taken action on it. This is a movement in America, and I'd like to see this Congress step up to it and get ahead of it instead of following. I want to see a national legislation so that there's a standard policy for all of America, just like there is for marriage. Only I'd like to see it done by the legislature rather than the judicial branch of government, and I think everybody on this committee would think the same thing with regard to legislation rather than judicial action on large policies. And the second topic I'd like to take up is some immigration legislation. One of them is my bill, H.R. 140, the Birthright Citizenship Act. It's a legislation that I have authored here in this Congress for a number of sessions, and it recognizes this, that there are this is according to an old study, more than 10 years old. We had testimony before this committee in this room that there were between 340,000 and 750,000 babies born in this country when both parents are unlawfully present in America. That's called birthright citizenship. It has spawned birth tourism. And at that time, the turnkey cost of, say, a pregnant woman from China could fly to the United States, stay here, have the baby, receive all of the medical care, and be housed for a period of time, fly back to China with a birth certificate for that child for a turnkey price of $30,000. That price has gone up a little bit since then, I understand. But we also has a number of these automatic citizenships taking place, automatic births taking place. And we know that there are people that just come to America to have a baby so that that baby can be a citizen, and then 18 years later the process begins to do the Family Reunification Act. It's happening with families out of the Middle East that are of sometimes of suspicious history as to whether they favor the United States or work against us. So that's an important piece of legislation. I recognize the 14th Amendment of the Constitution says that all persons born in the United States and subject to the jurisdiction thereof are American citizens. But this Congress needs to evaluate that clause subject to the jurisdiction thereof. And the scholarship that has testified in this room has sided with me on this, in that means owing allegiance to. And so that's where you start this, and I think it needs to happen here. Second immigration piece is the New IDEA Act, and that's H.R. 904. And I named it that because there are no new ideas in this Congress, and it was a little bit, I thought I'd just test that out. But it does come together. IDEA, the acronym stands for the Illegal Deduction Elimination Act, and it clarifies that wages and benefits paid to illegals are not tax deductible for federal income tax purposes. And then it denies those wages and benefits as a business expense to the employer, so it's a powerful deterrent, and it moves those dollars from a Schedule C expense back over into the gross receipts column where they show up as net income, taxable interest and penalty. It brings the IRS into the immigration enforcement process, and it ties together the Social Security Administration and the Department of Homeland Security, so the right hand, the left hand, and the middle hand of government all know what each other's doing, and they're working working on a common cause. It makes E-Verify permanent, but not mandatory, and it does give safe harbor for the employers who use E-Verify. So this is a smart, costless, effective immigration enforcement. And then in seconds, I will say H.R. 2260, the E-Bonding for Immigration Integrity Act. The President's working on this through executive action. I brought this to him, he agreed, but we can apply bonding to people coming in here on visas, and with that, the bonding can bring about enforcement, encourage them to go back home. I'd conclude my remarks and appreciate the opportunity to testify before this committee.
Thank you, sir. We'll now hear from the gentlewoman from New Mexico, Representative Holland.
Sorry about that. Thank you. Thank you for this opportunity to share some key priorities that impact the lives of New Mexicans. I proudly hail from a majority-minority state where nearly half the population is Hispanic. That's why I urge this committee to consider H.R. 2729, the Protect Immigration Act of 2019. This bill discontinues the 287G program that authorizes state and local law enforcement to collaborate with U.S. Immigration and Customs Enforcement in investigating, apprehending, and detaining undocumented people. This bill clarifies immigration enforcement is solely a function of the federal government, as it truly is. Collaboration between ICE and state and local law enforcement can destroy trust among an entire community. Across the nation, people don't call law enforcement in emergency situations or seek justice in the court for fear of being profiled, deported, or detained. This is unacceptable and doesn't serve or protect our communities. Many times, such people are disadvantaged and are not criminals. They're individuals who may make simple mistakes, like the undocumented woman living in my district since 2000 who went to court for a speeding ticket. Instead of being able to present her case and pay her fine, she was arrested by ICE. Our community should know they can safely call the police, seek justice as a victim, or pay a simple speeding fine. Sowing fear and distrust between communities and law enforcement makes everyone less safe. And that is what happens when we ask local law enforcement to do ICE's job. We cannot place the safety of our communities at risk due to distrust in law enforcement and in our justice system. As co-chair of the Native American Caucus and one of the first Native American women elected to Congress, one of my top priorities is to address the epidemic of missing and murdered Indigenous women. I want to thank this committee for supporting my 2 amendments to VAWA to expand the Tribal Access Program database and to provide victim advocate services to urban Indians. While this was an important step, homicide continues to be the leading cause of death for Native women between ages 10 and 24. Tragically, Native women experience murder rates 10 times that of the national average. That's why I urge you to act on the Not Invisible Act, which is the first bill in history to be introduced by all 4 congressional members of federally recognized tribes. This bill will establish an advisory committee to the Departments of Justice and Interior on violent crime comprised of law enforcement, tribal leaders, federal partners, service providers, and survivors. It would also create best practices for combating the epidemic of missing persons, murder, and trafficking of Native Americans and Alaska Natives, and would create a position for an expert within the Bureau of Indian Affairs charged with improving coordination of violent crime prevention efforts across federal agencies. Congress must also address the barriers that stand in the way of efficient law enforcement agency data sharing and officer recruitment and retention, both of which are imperative to address the crisis of missing and murdered Indigenous women. I also urge this committee to move my Badges Act, which will increase the effectiveness of federal missing persons resources and give tribes and states the funding to coordinate response efforts. These bills are important steps to moving toward combating the overwhelming number of domestic violence and gender-based crimes in Indian country and will move tribes closer to true self-governance. Thank you so much for hearing me, and I look forward to working with you to ensure that people from all communities feel safe and free from violence. And I yield.
Thank you, Representative Holland. Next, we will hear from Mr. Malinowski, the representative from New Jersey.
Thank you, Madam Chair, Ranking Member. I very much appreciate the opportunity to testify before you on behalf of the 7th District in New Jersey. I'm here today to address just one issue, the rising threat of white supremacist terrorism. Over the past several years, our country has done an extremely good job protecting ourselves against terrorism committed by groups outside the United States, like Al-Qaeda and ISIS. We have not done nearly as well preventing attacks by people who have been radicalized by a neo-Nazi and white supremacist movement that has its origins within the United States, but is becoming increasingly transnational. FBI Director Wray has told us that most of the Bureau's terrorism arrests in the U.S. now involve some form of white supremacy. According to the Anti-Defamation League, virtually every deadly terrorist attack in the United States in the last 2 years was committed by a member of this movement. It's a movement united by a common belief that immigration is causing the so-called replacement of the white race, and by a determination to create chaos and conflict by attacking Jews, Muslims, Hispanics, members of other religious and ethnic minority groups. The threat and the ideology inspiring it is absolutely clear from the deadly attacks in El Paso, in Charleston, in Pittsburgh. In each case, as well as in the horrible terrorist attack committed in Christchurch, New Zealand, the attackers cited exactly the same fear of invasion by immigrants. And it's pretty plain these people are becoming emboldened today. We see this in the crackpot conspiracy theories that are spreading virally on the internet. We see it in swastikas suddenly appearing on the walls of schools. We've had 6 such incidents in just one town in my district, Summit, New Jersey, in the past year. And we know it's not just about actual loss of life, as bad as that it is about the daily fear of loss of life. In my district, virtually every single synagogue and Jewish community center either has armed security or is wrestling with the question of whether to have it. State police come to mosque for Friday prayers. Now, there are actions we have to take in response to this that fall outside the purview of the Judiciary Committee. I'll be leading an effort to try to restore funding for programs at the Department of Homeland Security that combat violent extremism in the United States that were cut a couple of years ago. Many of us are pressing social media companies to do more to combat online radicalization and pressing the State Department to designate foreign white supremacist groups as terrorist organizations. But as busy as the Judiciary Committee is these days, and I know you are busy, I think it is imperative that this committee do its part. There's currently legislation pending in the House and Senate that would strengthen our government's ability to defeat domestic terrorism. This includes the Domestic Terrorism Prevention Act, of which I'm an original co-sponsor, which would beef up the Justice Department units responsible for addressing this threat and improve data collection. There's the Data Act and the No Hate Act. We also need to consider the difficult question of whether we should pass a domestic counterterrorism statute. While it's true that acts of mass murder committed by white supremacists, like hate crimes, can be prosecuted as ordinary crimes, I think there is a strong argument for enabling the Justice Department to prosecute these people for what they are, terrorists, and thus signaling that this effort must be a greater priority in terms of protection of our country. It's also important for this committee to continue to hold hearings and to conduct its basic oversight work to ensure that the FBI and DOJ pay sufficient attention to this threat and that they know we will have their back when they do. We will provide the resources and the authorities that they need. Madam Chair, it is far past time that our country starts taking the threat posed by white supremacist terrorism as seriously and as urgently as we have rightly taken the threat posed by terrorist groups based outside the United States. There's not a moment to be lost. Thank you.
Thank you very much. We'll now hear from the gentleman from Illinois, Mr. Quigley.
I want to thank the chairman, the ranking member, and the committee for allowing me to speak today. I hope you will strongly consider and pass two of the bills I have currently referred to this committee. The first is H.R. 1671, the NICS Denial Notification Act, which will help state law enforcement better enforce existing gun laws and respond to warning signs of criminal behavior. Keeping dangerous weapons out of the hands of dangerous people is a non-negotiable priority for my constituents. Every year in Chicago, nearly 700 children are victims of gun violence. 66 of these children die as a result of injuries sustained from bullets. And across America, 89 people are killed daily. 7 of these 89 are children. Every day, mothers, fathers, sisters, brothers, aunts, uncles, grandparents, and friends learn that a loved one has been killed by a bullet. Over the past decade, we have seen mass shooting after mass shooting. In fact, just this summer, in a span of less than 13 hours, 2 communities in our country were faced with the tragedy of a mass shooting. 32 lives were cut short by gun violence in less than a day. We can do something about this. On August 31st, Midland, Texas suffered another senseless and tragic mass shooting. As you may know, the perpetrator in that incident failed a background check in 2014 when he attempted to purchase a gun. He later purchased a firearm through a private sale. Taking action to prevent that scenario from ever happening again is why I've come here today. My bill, the NICS Denial Notification Act, is one of the few bipartisan gun safety bills in Congress. It would help state law enforcement better enforce existing gun laws by establishing an alert system to notify them when individuals legally prohibited from purchasing a firearm attempt to do so. In 37 states and the District of Columbia, which rely on the FBI to run some or all of their background checks, state authorities are generally not aware when prohibited persons fail background checks run by the FBI. As a result, these states and D.C. lack critical law enforcement intelligence that they could use to try to keep their communities safe. By automatically notifying state and local law enforcement when a prohibited individual attempts to acquire a gun, we can help law enforcement intercept a dangerous person before they acquire a weapon and commit a violent crime. Had this been the law, there is a chance that the horrific mass shooting in Midland may never have occurred. On a much different note, I also want to use this time to discuss my bipartisan JOLT Act. H.R. 2187, the Jobs Originating Through Launching Travel Act, is aptly named, as it is designed to give a jolt to the U.S. economy by improving inbound travel to the U.S. while simultaneously improving our national security. Travel and tourism are crucially important in a district like mine in Chicago, but also all over the U.S. Cities, towns, big and small, benefit from a robust travel and tourism industry. The impacts are felt in food service, lodging, transportation, retail, amusement, and recreation activities. As our nation's #1 service, export tourism generates $2.5 trillion in economic activity every year, with nearly $200 billion in spending coming from visa-free travelers alone. But of course, our ports of entry must be fortified and the infrastructure improved in order to meet the needs and unique security challenges international travelers pose. The JOLT Act deals with these issues and opportunities, directly providing for a safer, more prosperous country. It encourages Canadian tourism to the U.S. by increasing the length of stay for Canadian visitors from 180 to 240 days. Second, the bill importantly renames the Visa Waiver Program to a more appropriate Secure Travel Partnership Program. This name change is more than just branding. It more accurately reflects the mission and security parameters required for qualified countries to participate. This includes maintaining high airport security standards, supporting operation for an effective air marshal program, and cooperating with the U.S. to fight terrorism by sharing terrorists' next threat. The bill also makes visa processing more efficient, setting a goal for 15 days for reviews of non-immigrant visas. And finally, the bill contains reporting requirements for DHS to share with Congress on how many people visit the U.S. under this travel program. Simply put, we should do everything we can to expand and strengthen the successful program, and I thank you for the opportunity to speak with you today.
Thank you very much. Next, the chair recognizes the gentleman from Northern New York, Mr. Katko. Can you?
Sorry. I would like to begin by thanking the committee for the opportunity to speak today on H.R. 3657, the Bill's Promise Act. I was proud to introduce H.R. 3657 earlier this Congress with Representative Hank Johnson of Georgia. And I'm pleased that the legislation has already received strong bipartisan support from the committee, including from Ranking Member Collins and representatives on both sides of the aisle, including members of Congress Roby, Swalwell, Klein, Sensenbrenner, Dean, Shabbat, Buck, and hopefully soon, Ms. Scanlon. When properly administered, as a former federal prosecutor and one for 20 years, I routinely dealt with pretrial release matters, and they are an important tool for judges, an important tool for prosecutors, important tool for the system to ensure that only those that truly deserve to be incarcerated pending trial are incarcerated pending trial. When properly administered, the programs help to address the significant resource and capacity restrictions facing our courts. Unfortunately, failures in this system can jeopardize availability of pretrial release services and threaten the safety of victims, the accused, and the men and women who administer these services. The community that I represent in Central New York knows these consequences all too well. And I want to delve into the facts of a particular case to illustrate my point. In 2013, I was a federal prosecutor in Syracuse, New York. And one day we received horrific news. Somebody that was charged with possessing child pornography and who was on pretrial release, justifiably so, most likely because he had no priors, kidnapped a woman and a 10-year-old girl, her daughter, repeatedly raped the girl in front of the mother, and then murdered the mother. And as subsequent facts evolved, it was determined that this individual, while on pretrial release and on electronic monitoring, had tampered with his bracelet 46 times before getting out and before actually committing the crime. And what was learned was that 46 alarms went to the company, 46 alarms went to probation, and those alarms were largely ignored as an anomaly. And he knew this, the defendant, and he eventually took the bracelet off and went and committed the horrific crime that he committed. What I found out subsequently was this was not an isolated incident. I've spoken to members on both sides of the aisle all throughout Congress, Sheila Jackson Lee, for example, and many others, who have encountered similar things in their district. Stories so ridiculous as electronic monitoring not being monitored 24/7, closing down at 9 o'clock at night and then starting up at 9 o'clock in the morning. One individual knew that, and after 9 o'clock at night, he went out and murdered somebody. And there's facts like this all over, and I will spare you some of the gory details. But what this bill tries to do is to address this, not by denigrating pretrial release, but by trying to enhance it by doing appropriate things. And by the way, the bill is named for Bill's Promise because the individual who came upon this horrific scene and held this woman in his arms as she died made a promise to her that he'd make sure this never happened again. And he's made it his life work. So while these circumstances I described as one case were extreme, they certainly are not isolated, and further oversight is needed to ensure that they are never allowed to occur again. A recent analysis by the Pew Charitable Trust found a 140% increase in the use of electronic monitoring devices nationwide over a 10-year period. As this and other technologies are deployed to improve the administration of pretrial release programs, Congress must take action to promote accountability and maintain the integrity of our pretrial release system. The Bill's Promise Act represents a critical step in this process. The legislation would authorize a comprehensive study on the administration of pretrial release services, with a specific focus on monitoring practices for the individuals on pretrial release. Critically, this legislation would also examine resource and capacity issues impacting the administration of pretrial release services and call for recommendations to ensure their continued availability. Having received endorsements from the National Alliance to End Sexual Violence, the Fraternal Order of Police, the National Sheriff's Association, to name a few, I ask that the committee strongly consider taking up this legislation. On a final note, I want to highlight the advocacy of Bill Craig, the gentleman I described. He's a steadfast advocate for safety in Central New York community, and his advocacy has made this legislation possible. He was the first person on the scene, I said, after this horrific event that occurred in 2013. This experience motivated Bill to make a promise that senseless and preventable acts of violence, like those he witnessed, would never be incurred again. I'm here today asking you, all of you, to help him keep that promise. Thank you, and I yield back.
Thank you very much. We'll next hear from the gentleman from Ohio, Mr. Stivers.
Thank you, Madam Chair and Ranking Member. I appreciate the opportunity to testify before you on intellectual property reforms today. Our founding fathers knew that our nation's economic success would thrive with the hard work of American inventors and their ideas. That's why in the Constitution, Article 1, Section 8, they gave Congress the power to promote the progress of science and the useful arts, which has been considered the gold standard in the patent system around the world. Unfortunately, in recent years, some of our unintended consequences from laws and judicial decisions have threatened our status as the leader in innovation. Congress passed the America Invents Act, which promised a faster, fairer, and cheaper method of challenging the validity of patents that have been granted by the U.S. Patent and Trademark Office. It created the Patent Trial Appeal Board, PTAB, and I support the PTAB, but unfortunately what's happened, because the standards at the PTAB are lower than the standards in the court, is we've tipped the scales in favor of those who have the deepest pockets instead of those who have the best ideas. And innovators have always thrived in trying to take down the Goliath of the day with their new slingshot, but the current system denies that opportunity to some because they might not be deep pockets. That's why, along with Congressman Bill Foster, Tom McClintock, Nydia Velasquez, we've introduced the bipartisan Stronger Patents Act. This legislation seeks to help Congress keep its original promise in the America Invents Act and create a cheaper, faster, fairer process in the Patent Trial and Appeal Board. It ensures that the PTAB uses the same standards of construction as the federal court system. That seems pretty simple, but because the standards are different and you get more protections at the court system, everything from the PTAB ends up getting appealed. When you appeal everything, it costs more money, it takes longer, and deeper pockets win more often. That contradiction and uncertainty has eroded the confidence in our system. Thankfully, the director of the U.S. Patent and Trademark Office, Director Iancu, has implemented the harmonization of claim construction through a rulemaking process, but that's temporary, and we need to enshrine it in law. And the Stronger Patent Act does just that. I think it's really important. The second thing the Stronger Patent Act does is it restores injunctive relief. If you're stealing my personal property, I can stop you. But if you're stealing my intellectual property today, I might not be able to stop you because I can't get injunctive relief. Again, this just leans things toward the deeper pockets. In fact, there's a new term out there, inside intellectual property. And that term is that they are going to try to take your property until you stop them. It's called efficient infringement. And it's only efficient because we don't have injunctions. We need to bring back injunctions and restore the property rights that are enshrined in the Constitution again. This committee has an opportunity to discuss and debate these PTO reforms, and I look forward to working with you as we do that. We can restore our Patent and Trademark Office to a place that is the gold standard for the world. Another thing that the committee, I hope, will consider over time is the patent eligibility sections that haven't been updated since 1952, long before jets, artificial intelligence, mapping of the human genome, even the fax machine were not thought of in 1952. This absence of congressional action since 1952 has allowed the courts to set policy on what can and cannot get a patent. So we need to take a serious look at that, and I hope you'll look at that as well. There's some things being discussed and worked on with Senator Tom Tillis, Chris Coons, Chris Collins, Hank Johnson, and I around patent eligibility to help clarify it, and I hope you'll take some time to look at it. Think back to 1952. The three of us probably weren't born in 1952. You don't look like you were, so think about how long ago that was. And half the pictures in this room weren't up in 1952. That was 2 generations ago. So we do need to look at patent eligibility, but I hope you'll take a serious look at the Stronger Patents Act, because it's really important, because it will help keep our economy competitive into the future. I want to thank the committee for this opportunity. I'm happy to answer any questions and look forward to working with you on intellectual property reforms.
Thank you very much. Next, the committee will hear from Mr. Marshall from Kansas.
Thank you, Madam Chairman and Ranking Member. Good morning. The Second Amendment is a fundamental right enshrined in our Constitution. As a lifelong sportsman and gun owner, I remain committed to seeing that it is not infringed upon and will strongly oppose any legislation that would attempt to strip that right away from law-abiding citizens. Americans have a right to protect themselves and those close to them. I cannot imagine living in rural Kansas, where a sheriff's officer is often 60 miles away, without my God-given constitutionally guaranteed right to protect myself and my family. Last week, this committee advanced several anti-Second Amendment bills, including one on proposed red flag laws that would allow private citizens to request court orders for officials to confiscate people's legally obtained and constitutionally protected firearms. Proponents of this type of legislation say they would stop potential mass shootings before they occur, but red flag laws actually result in law-abiding citizens losing their ability to defend their families, all while losing their right to due process. These laws are too vague and would be abused beyond the stated purposes of the legislation by those who want to see a disarmed America. We, all of us, every member of Congress, we took an oath to defend and uphold the United States Constitution, and I will continue fighting against unconstitutional gun grabs by those who wish to abolish the Second Amendment. Madam Chair and Ranking Member, last week I took part in a hearing on the Born Alive Abortion Survivors Protection Act, which would protect babies born alive following an attempted abortion. I'm appalled that the vote on this bill has been blocked 80 times now, 80 times by House leadership. As an obstetrician who's delivered over 5,000 babies in Kansas, I never thought I'd be fighting harder to save babies' lives in the halls of Congress than in the delivery room. I'm calling on this committee to hold a hearing on this legislation and advance the bill to the floor for consideration by the full House. Kansans and pro-life Americans everywhere are demanding it. This shouldn't be complicated. This shouldn't be controversial. This is common sense legislation. The fact that this can't get a vote should make all of us hang our heads in shame. Madam Chair and Ranking Member, perhaps the biggest complaints I hear when I head back home and do town halls about Congress tend to come from the actions, or really the lack of actions, from this committee. The financial waste, the waste of time, the petty politics that comes from this room more often than anywhere else on the Hill. We've known for months that there was no collusion. We also know that there are key issues that Congress must address on behalf of the American people, like the USMCA NAFTA 2.0 trade agreement. We need to secure our borders. We need an infrastructure package. Those are just to name a few that the American public want done. Unfortunately, those of us up here on the far left would rather waste everyone's time and money, their tax dollars, with these senseless hearings and investigations. In all, more than half of all the Democrats in this chamber now support moving forward on impeachment and continue to ignore calls from the public to focus on more pressing matters, such as, again, bringing trade deals to the floor to help our nation's farmers and ranchers as well as our manufacturers. There can be no denial that the majority of this committee's sole agenda item is to buck the will of the American people and continue their attempts to impeach the president. Let's get on with the business of governing. Elections do matter. We are all learning that, and we'll get another chance in just a year. But I'm asking that we commit today that until that election, we actually get something done for the American people and not just work to make another made-for-TV soundbite. Thank you, and I yield back.
Thank you. I'll just note that votes have been called. There's 11 minutes remaining, so this will be the last witness. And with that, the gentleman from Tennessee, Mr. Rowe.
Thank you, Madam Chair. Too often as Americans, we tend to take our freedom for granted. But we should never forget that we owe our freedom to our nation's veterans. That's why it's so egregious that many veterans come home to find that they have to do battle with the VA, the very agency that's supposed to help and support them to protect their own constitutional rights. The problem occurs when VA, for whatever reason, determines that a veteran needs assistance managing his or her VA financial benefits and decides to appoint a fiduciary. Now, there are many reasons why that a veteran might need a fiduciary, such as a veteran who may have had a TBI injury and has difficulty with math and struggles to balance his or her checkbook. Unfortunately, there are serious unintended consequences when VA appoints a fiduciary. This is because once VA decides that the beneficiary needs help with finances, even though there may be no evidence that the individual may be a danger to himself or others, the department sends the veteran's name to the FBI added to the Nixus list. I want to be clear. Any individual who a court rules is a threat to themselves or others should not be permitted to possess a firearm. However, there is no evidence that those who need a fiduciary are a danger to society. It's important to remember that a VA bureaucrat makes this decision, not a judge. Unfortunately, VA's decision has serious consequences for veterans, including losing his or her Second Amendment rights. This means that the veteran can't go hunting, can't shoot at a target range, or even keep a firearm that's been in the family for generations. I'm also concerned because some recreational therapy programs, like the one at the VA Grand Junction Medical Center in Colorado, have found that hunting trips can be therapeutic for veterans with physical and psychological disabilities. Right now, there are probably veterans who could be helped by these programs but can't participate just because a VA bureaucrat appointed a fiduciary for them. Moreover, I'm troubled that I've heard from veterans that they do not seek care or benefits from VA because they fear that if they do, they will lose their Second Amendment rights. Just this week, I worked with one of our colleagues to assist a constituent who was so worried about the impact of VA's proposed fiduciary finding that he stated he would rather give up his VA benefits than lose his firearms. Barring law-abiding veterans from owning a weapon will not make our communities safer. If anything, it will discourage the veterans who protected our country from receiving the benefits that they've earned. I have a bill, H.R. 3826, which would prohibit VA from sending veterans' names to the Nixus list unless there is an order from a judge or magistrate that says the person may harm themselves or others. In 2017, this bill passed the House with bipartisan support. I know we don't always see eye to eye, but we should all agree that veterans who are willing to lay down their lives to protect freedom shouldn't have their own freedoms taken away without appropriate due process. I urge members to support and co-sponsor my bill, 3826, and hope you will recommend to the VA Committee Chair, Tucano, that he advance the bill. I would also like to take the opportunity to renew my concerns with House-passed language in H.R. 1112. If H.R. 1112 were enacted, it could expand the list of individuals who cannot possess a firearm to include 1.7 million veterans with an adjudication of service connection for a mental health condition. I hope we can all agree that a VA bureaucrat granting a compensation claim for PTSD or depression in no way equates to a judicial ruling that a veteran is a danger to society. I raised these concerns in February of 1112, and when H.R. 1112 was being debated on the House floor. I'm also grateful to the Veterans of Foreign War of the United States brought this issue to Judiciary Chairman Nadler's attention. As a result, he committed to ensuring that as H.R. 1112 proceeds, it would not negatively impact disabled veterans. Today, I would like to ask Chairman Nadler to reaffirm the commitment he made on the House floor and request that he provide me with an update on his progress addressing this matter. And as the chairman of the committee, I've traveled across this country talking to veterans. And one of the concerns, Madam Chair, that I have is that veterans from Long Island to Los Angeles have told me this. They're concerned that if they have mental health treatment at the VA, that their weapons will be taken away. I would encourage this committee to take this up, and I yield back my time, and thank you for the opportunity to be here.
Thank you very much for your testimony. This concludes today's hearing. We thank all our witnesses for participating and discussing important views regarding immigration, criminal justice, gun safety, etc. Without objection? Okay. Without objection, all members will have 5 legislative days to submit additional materials for the record. And without objection, this hearing is adjourned.